Good morning, everyone. Welcome to everyone here in Assembly Judiciary that's here in Carson City, as well as anyone in Las Vegas, and of course, anyone watching online through Nellis or through YouTube. Committee Secretary, will you please take the roll?
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola, Moore, Nadeem, Orentlicker, Roth, Yurk, Chair Miller.
Here. And with that, just a few reminders before we get started. Please make sure you turn down your electric devices so they don't interrupt anyone today throughout our meeting. We'll begin with a work session and then have two bill hearings. As you know, this is the time where you'll see members moving on and off the dais. They're going to their own bill hearings or work sessions, so please don't take that as, a means of distraction, the same as you see them on their laptops and fumbling through tons of paper as well up here. Of course, I'll go ahead and provide the meeting ID right now. The phone number for today, if you wish to call in to testify or to make public comment later at the end of today's meeting, the number is 888-475-4499. Today's meeting ID is 895-698-28444. And of course, we ask that anyone making public comment or testifying keep their comments to 2 minutes each, and anyone presenting bills keep their presentation to 15 minutes. With that, anyone speaking, of course, it's very difficult to remember, but we will remind you if necessary. Please remember to state your name and to spell it so that we have it correct for the record. And with that, also, just so you know, I will be taking the bills out of order when we get to the bill section. We will begin with Assembly Bill 490 and then AB 167. But for now, we're going to begin our work session, so I will turn it over to our policy analyst.
Thank you, Chair Miller. For the record, Cesar Mogarejo, Committee Policy Analyst, and I would like to note that as nonpartisan staff, I can neither support nor oppose any of the measures that come before this committee. And our first bill on the work session today is Assembly Bill 55, which is sponsored by this committee on behalf of the Office of Traffic Safety of the Department of Public Safety and was heard on February 18, 2025. Assembly Bill 25 revises provisions concerning data collection and analysis related to motor vehicle crashes. There is an amendment that was submitted by Amy Davey, Administrator of the Office of Traffic Safety, which proposes to amend Section 1 by removing specific timelines for post-mortem blood draw reporting, instead requiring findings to be reported upon receipt, and replacing the requirement to test for specific prohibitive substances with a broader analysis of commonly abused drugs as determined by the examiner. And that's all the amendments.
Thank you. Members, are there any questions? Not seeing any, I'll entertain a motion to amend and do pass. So moved. I have a motion from Vice Chair Marzola. Do I have a second? Oh, I have a second from Assembly Member Gray. Is there any additional questions or comments? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes. I will assign that floor statement to Assembly Member Cole. You're welcome. Assembly Bill 58.
Thank you, Chair Miller. For the record, Cesar Mogarejo, Committee Policy Analyst. Next bill, Assembly 58, is sponsored by this committee on behalf of the Nevada Gaming Control Board. Assembly Bill 58 makes various changes concerning Nevada's gaming laws. There is an amendment submitted by Sebastian Ross, Senior Policy Counsel of the Nevada Gaming Control Board, which proposes to delete Section 1 from the bill, which revises the term associated equipment. And that's all the amendments.
Thank you. Members, any questions? Not seeing any, I'll entertain a motion to amend and do pass. So I have a motion from Vice Chair Marzola. Do I have a second? Second. I have a second from Assembly Member Nadeem. Any additional questions or comments? Okay, all those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I will go ahead and assign that floor statement to Assembly Member Dahlia.
Thank you, Chair Miller. For the record, Cesar Melgarejo, Committee Policy Analyst. Next bill is Assembly Bill 76, which is sponsored by this committee on behalf of the Cannabis Compliance Board. There is an amendment. There is an amendment submitted by James Hum, Executive Director of the Cannabis Compliance Board, which includes but not limited to clarifying the definition of synthetic cannabinoids, amending confidentiality provisions, reinstating the board's authority in enforcement and disciplinary actions, refining regulations on cannabis packaging and advertising, modifying limits on cannabis products, and addressing procedures for cannabis transportation and public health hazards. And Chair Miller, that's all the amendments.
Thank you so much. Members, any questions? Not seeing any, I'll entertain a motion to amend and do pass. I have a motion from Vice Chair Marzola. Do I have a second? I have a second from Assemblymember Cole. Any additional questions or comments? All right, I'll take a vote. All those in favor, please say aye. Aye. Anyone opposed? Nay. Okay, let me get the count for nay. I have Assemblymember Hardy, Assemblymember Gray, and Assemblymember Hanson. Are those just my three nays? Okay, thank you so much. With that, I will assign the floor statement to Assemblymember Ordlicker.
Thank you, Chair.
You're welcome. AB 119.
Thank you, Chair Miller. For the record, Cesar Melgarejo, Committee Policy Analyst. AB 119, sponsored by Assemblymember Yeager, and was heard on March 12, 2025. AB 119 establishes provisions authorizing the Attorney General to investigate alleged paramilitary activity. And there are three separate amendments to this bill. The first is from Assemblymember Roth, proposing to add herself as a co-sponsor. The second is from Mary B. McCord, Executive Director, Institute for Constitutional Advocacy and Protection, and visiting professor at the law, Georgetown University Law Center. Proposes clarifying that paramilitary activity requires individuals or groups to be armed with dangerous weapons, and the Clark County Public Defender's Office proposes prohibiting the Attorney General from using information obtained through investigative demands on criminal cases. I would note for the committee members that the Public Defender's Amendment includes a proposal to add that the provisions regarding the paramilitary activity do not apply to any lawful expression in the First Amendment. However, this amendment was not accepted by the bill sponsor. Chair Miller, that's all the amendments.
Thank you so much. Did we check with the bill sponsor about the First Amendment, adding Assemblymember Roth? I'm teasing. She presented the bill, so. With that, members, any additional questions or comments? Sure, Assemblymember LaRue Hatch.
Thank you, Chair. I just wanted to clarify then, for the Public Defender Amendment, are we voting to, we're voting on just the first part of it, but not the second part of it?
Correct. The
Okay.
second part was not included in the amendment.
Perfect, thank you.
Any additional questions or comments? Okay, with that, I'll take a motion to amend and do pass. I have a motion from Assemblymember Marzola. I'm sorry, Vice Chair Marzola. Do I have a second? Second. I have a second from Assemblymember LaRue Hatch. Any additional comments or questions? Okay, all those in favor, please say aye. Aye. Anyone opposed? Nay. Okay, can I see the hands of the nays? Okay, so I have Assemblymember Hardy, Assemblymember Gray, Assemblymember Cole, Assemblymember Urick, and Assemblymember Hanson as our noes. Thank you, and with that, I will go ahead and assign this floor statement to Assemblymember Roth. You're welcome. AB 137, please.
Thank you, Chair Miller. For the record, Cesar Melgarejo, Committee Policy Analyst. The next bill is Assembly Bill 137, which is sponsored by Assemblymember Torres Fawcett. This bill revises requirements for advertising the sale of personal property to satisfy a lien held by the owner of a self-storage facility. Assemblymember Torres Fawcett did submit an amendment, which is to add Assemblymember Hanson as a co-sponsor to this bill. And Chair Miller, that's all the amendments.
Thank you so much. Members, any additional questions or comments? Not seeing any, I will entertain a motion to amend and do pass. So moved. I have a motion from Vice Chair Marzola. Do I have a second? Second. I have a second from Assemblymember Hanson. And also, I'm going to ask, is this a friendly amendment? Okay. So with that, any additional questions or comments? All right, all those in favor, please say aye. Aye. Anyone opposed? Okay, and the motion passes unanimously. I will go ahead and assign that floor statement to Assemblymember Torres Fawcett. Assembly Bill 197, please.
Thank you, Chair Miller. For the record, Cesar Margarejo, Committee Policy Analyst. Assembly Bill 197 was sponsored by Assemblymember Backus and was heard by this committee on February 21, 2025. Assembly Bill 197 enacts provisions to strengthen protections concerning the confidentiality of personal information related to nonprofit organizations. Assemblymember Backus did submit an amendment for this bill, which is to amend Section 2 of the bill, including replacing non-financial support with in-kind services or goods, clarifying confidentiality exceptions for nonprofit donor information, expanding investigative exceptions, revising definitions related to nonprofits and donors, and adding Assemblymember Hafen as a co-sponsor. And Chair Miller, that's all the amendments.
Okay, thank you. Members, do we have any additional questions or comments? Not seeing any, I will entertain a motion. I have a motion from Vice Chair Marzola and a second from Assemblymember Gray. Any additional questions or comments? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. With that, I will assign this floor statement to Assemblymember Backus. Assembly Bill 246, please.
Thank you, Chair Miller. For the record, Cesar Margarejo, Committee Policy Analyst. Assembly Bill 246 is sponsored by Assemblymember Considine, and it was heard on February 27, 2025. This bill revises provisions concerning food-related operations within Nevada's Department of Corrections. Assemblymember Backus did submit Assemblymember Considine did submit an amendment to this bill to require Nevada Department of Corrections to conduct a comprehensive study on food services, establish a vocational farm program to the extent money is available, adopt regulations for independent inspections by a registered dietitian who is neither an employee of NDOC nor affiliated with a contracted food vendor, and limit contract terms with the current food vendor during the study. Additionally, the amendment requires NDOC to request cost proposals from multiple food service entities and publicly release study findings. And Chair Miller, that's all the amendments.
Thank you so much. Members, any additional questions or comments? Not seeing any, I'll take a motion to amend it to behalf. So moved. Thank you. I have a motion from Vice Chair Marzola for Assembly Bill 246. Do I have a second? Second. I have a second from Assemblymember Moore. Any additional comments or questions? Not seeing any, I'll take a vote. All those in favor, please say aye. Aye. Anyone opposed? And the motion passes unanimously. I'll go ahead and assign that floor statement to Assemblymember Considine. Thank you. And with that, thank you, members. That concludes our work session. We will move on to the next item on our agenda, which is the bill hearing for Assembly Bill 490. 490 revises provisions related to the courts and will be presented by Speaker Yeager. Welcome back, Speaker. Your hearing is open, so whenever you are ready, please proceed.
Thank you and good morning, Chair Miller, Vice Chair Marzola, and members of the Assembly Judiciary Committee. My name is Steve Yeager. I represent Assembly District 9, which is in southwest Las Vegas, and it is an honor to present Assembly Bill 490 to you this morning. Assembly Bill 490 is about public access to our state's most important court cases. Under existing law, the First Judicial District Court here in Carson City has exclusive jurisdiction over certain cases. This means that these cases cannot, by law, be heard anywhere else in the state. I suspect the First Judicial District was given exclusive jurisdiction because the court is located here in Carson City, which is Nevada's capital. While exclusive jurisdiction might have made sense when various statutes were enacted, it doesn't make sense in our modern world. Unfortunately, many judicial districts in Nevada, including the first, have not modernized to a point where the public has meaningful access to what is happening in those courts. This means that documents are not easily accessible, nor are the hearings easily accessible for the public to watch. For instance, there is no online access to documents, greatly slowing down the process of obtaining documents from these courts. There is no online access to hearings, meaning neither the press nor the public can watch proceedings without traveling to the courthouse and watching them live and in person. This leaves Nevadans in the dark about what is happening in these cases. The result of this is that the media and the public are largely left in the dark, and again, these are some of the most important matters in our state, matters like petition initiatives and election-related challenges and issues. According to Tabitha Mueller, a politics reporter at the Nevada Independent, quote, "Accessing court information quickly and efficiently is essential for informing the public. The current setup often results in delays, hindering our ability to provide timely and accurate reporting." Caitlin Newberg, a reporter at the Las Vegas Review-Journal, said at a panel on the issue that wider online access would ensure court documents aren't limited to just a handful of people who learn over time how to navigate the system and learn the right person in time to call a court. Quote, "Having an open court system lets us follow these cases through the system, continue to report on them, and give people access to information, which really is a basic foundation of both journalism and our democracy as a whole," Newberg said. In addition, when courts have fewer than 3 judges, each litigant can preempt a judge, meaning that the judge who might hear the case will typically be a retired senior judge that does not have to face the voters in the next election. This is contrary to Nevada's current public policy of electing our judges and making them go before the voters. The lack of modernization results in a lack of confidence in the judicial system and judicial proceedings, especially when it comes to contentious elections cases, which we've had a number of in this state over the past few years. Chair, the bill itself is relatively straightforward. Let me take you through it. Section 1 of the bill is a technical change that actually implements the bill. Section 2 of the bill requires that any reference to the, quote, "first judicial district," end quote, in statute must be interpreted to include, quote, "a qualified district court," end quote. And then Section 3 defines what a qualified district court is. It is a court in which there are 3 or more judges. There is electronic filing, storage, and reproduction process, and electronic access to its documents and hearings. So thank you, Chair and committee members, and I am now available for questions regarding Assembly Bill 490.
Thank you so much, Speaker. I'm going to give members a moment to process and request a question, just because the presentation was so swift, and so.
Chair Steve Yeager for the record. I know it's deadline week, so I'm trying to keep things very quick for you all this morning, but we'll take any questions now, and obviously, even after today's hearings, I'm available for questions if folks have some.
Okay. Our first question is from Assemblymember Ordlicker.
Thank you, Chair, and thank you for bringing the bill. So I understand about the kinds of cases where the First Judicial Circuit has exclusive jurisdiction and to allow other courts. But looking at the digest, it sounds like just regular criminal or civil cases that are in the First Judicial Circuit because it's where the case arose can also be heard now in other courts. Is that right? Under this bill.
Steve Yeager for the record. That's a really good question, Assemblymember Ortlicker, and through the chair to you. This is kind of where.
Please go direct.
Thank you so much, Chair. This is kind of where Section 2 comes into play. So Section 2 of the bill says, except as otherwise expressly provided or required by the context. So to answer your question, if jurisdiction is in the First Judicial District Court because a civil or criminal case that's not otherwise specified by statute originates here, for instance, a criminal case originates in the Justice Court here, or maybe there's a Justice Court civil case and there's an appeal to the District Court, that would stay the same. We're going to keep that tracking. So if it sort of originates not through statute, but just by basis of where, sort of the event happened, it will stay in the First Judicial District Court. Now, to your point, there are some things that are expressly listed in the digest on the bill about certain actions, including certain criminal petitions and certain disputes relating to property. Those are things that are like specified in statute as jurisdiction being in the First Judicial District Court. So these are specialized types of criminal challenges or property challenges. So I think it wasn't listed out because, here's how I kind of tried to figure out what cases are encompassed. I went into our great legislative website. I went into the NRS and I just did a search in quotes for First Judicial District Court, and I got about 16 to 18 hits, which were specific kinds of cases. So, for instance, listed here, final decisions made by the Secretary of State, Department of Transportation, or Commissioner of Insurance findings. So those that are listed expressly in statute, you'd be able to go to any qualified district court, but we're not trying to disrupt, like if you committed a crime in Carson City, your case is going to stay in Carson City, and if you filed otherwise sort of normal civil suit here in Carson City, it would stay in the First Judicial District Court.
Thank you. Our next question is from Assemblymember Cole.
Thank you, Chair. I appreciate that. My question kind of tied into that. Can you give us a list of those 16 to 18? That would be awesome. I know I'm a judicial nerd, right? But I guess my question is in Section 3, is there any concern that you will sweep somebody into a court that's not close or convenient to them because of the qualified court aspect?
Steve Yeager, for the record. I can get you that list. I don't have it with me. I do know there are some of the cases are listed in the digest by statute, but when I look through sort of the highlighted cases, and really the ones that caused me to bring this bill were elections, petition initiatives, sort of NDOT, Department of Transportation final approvals, Commissioner of Insurance. But I can get that list for you. I just was not able to get that pulled together this weekend. But, to your question, I suppose there is that issue because, one of the questions that hasn't been asked yet, but is, which courts would qualify under this bill? And I think the easiest way to look at it is the requirement of 3 or more district court judges. Right now, only 3 judicial districts in the state have 3 or more district court judges. That would be the 2nd Judicial District in Washoe, the 8th in Clark, and the 4th, which is Elko, that has 3. I'm certainly willing to have a conversation with the 1st Judicial District Court about whether they ought to have an additional judge. They have 2 right now. Right? So by default, they would not be able to take these cases. And so that would exclude if you are otherwise in Carson City, you would have to go to Clark or Washoe. But if we think about it, if you are in Clark or Washoe, you're already coming to Carson City. And not only are you coming to Carson City, like you are physically coming to Carson City to file documents and for the hearing. So the difference here, I think, is even if you're located outside of one of those judicial districts, you have access to online filing. So you don't actually have to pay someone to go down to the courthouse and file the document. You can pull documents offline, and the members of the public would have the chance to participate. Obviously, if you're going to argue in the court, you're going to have to go there in person, no matter which court that you're in. But so I'm willing to have those discussions. Really, for me, the concern behind this bill, electronic filing is more a convenience for lawyers, but also it is for the media. To get documents, they actually have to come to the court, fill out the paperwork, talk to someone on the phone. But really, it's the public, right? We have to wait, unless you're able to come to Carson City to hear an argument, we have to wait until somebody reports on a case. And we have some pretty significant elections cases over the last, at least the last 2 presidential elections, and then our petition initiatives obviously almost always get challenged, no matter who brings the petition initiative. So it is important to me that, the public have the ability to watch those without having to travel to Carson City, but I will concede that there is the possibility that someone's going to have to travel, though online should help.
Thank you. Our next question is from Assemblymember Gray.
Thank you. Good morning, Mr. Speaker. Question, never having filed a case or been a party to a case, is there a possibility of filing a case in a court that may be perceived as more friendly, or manipulating the system so it could be moved, so the venue could be changed to a more friendly jurisdiction?
Steve Yeager, for the record. I mean, I think there's probably a lot of different answers to that question depending on who you ask. I would say attorneys typically do try to file somewhere where they feel like it's a little bit more friendly. Hard to say if that's going to be the case. I mean, I will just add a little bit of context because I think the first judicial district is pretty unique. For a long time, and we've had turnover now where we have 2 new district court judges here in the first judicial district. The 2 judges who were here prior were here for a very long time, and I think they had developed an expertise on these kinds of cases. I mean, they had to, right? Because they're the only ones in the state that heard these cases. We don't have that same consideration anymore because we've had a turnover, I think, within the last year and a half, maybe more recently. We've had a complete turnover. Those 2 prior judges retired, 2 new judges are there. So, my concern was like, well, we don't want to lose the expertise, right? But we're not going to lose that now. So I think, these cases should be open to all judges because all district court judges in the state, at least in theory, right, are competent, were elected, are able to do research and provide rulings on these cases. But, under this bill, if this were to pass, I mean, a litigant would have an option. Do I file in Washoe? Do I file in Clark? Do I file in Elko if they meet the other requirements of the bill with electronic filings, or if we were to give another judge to the first, do they file there? And that would just be up to the attorneys. But I don't know that these kind of cases, there's any track record of someone to look and say one court is more favorable than the others due to the 2 retirements that we had in the first judicial district court. There just aren't published decisions by the judges that would be hearing these kind of cases. So that's always a consideration, but I'm not particularly concerned about it because of the turnover we had in the first judicial district.
Thank you. And I don't see any additional questions, so I will go ahead and open it up for testimony. Beginning here in Carson City, anyone wishing to testify in support of Assembly Bill 490? Not seeing anyone. Is there anyone in Las Vegas that would like to testify? Okay, broadcasting, will you open the lines, please?
If you would like to testify in support of Assembly Bill 490, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of AB 490, please press star 9 now. Chair, there are no callers wishing to testify in support at this time.
Thank you. Then I will open it up for opposition testimony, beginning here in Carson City. Not seeing any. I don't believe anyone's approaching in Las Vegas to testify. Broadcasting, will you open the lines, please?
If you would like to testify in opposition to Assembly Bill 490, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you so much. Then I will open it up here in Carson City for testimony in neutral. Not seeing anyone, and I don't see anyone approaching in Las Vegas. Will you open the lines, please, for testimony in neutral?
If you would like to testify in neutral for Assembly Bill 490, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in neutral at this time.
Thank you so much. Then I will, Speaker Yeager, do you have any final comments? Okay, thank you so much. With that, I will go ahead and close the hearing on Assembly Bill 490. Next up today, we have Assembly Bill 167. So I'm going to open the hearing and give our bill sponsor and co-presenters a few moments to get settled. And so, Assembly Member, whenever you're settled and ready, and you know the drill, so you're open and we're just waiting on you all. And I promise I didn't time that to see if you can beat his record, but no stress.
Good morning, Chair Miller, Vice Chair Marzola, and associated or my friendly colleagues on the Judiciary Committee. I'm Assemblywoman Alexis Hansen. That's ALEXISHANSEN, and I represent Assembly District 32. And it's a pleasure to be before you today. I'm really going to just take a moment to do a little introductory remarks and introduce the guests at the table. It's been my privilege to be able to get affiliated with Satara Raganti to my right, who is the youth legislator for Senate District 15. It was in participating and helping with the youth legislature this fall that I got to know Satara and get familiar with the legislation she was bringing forward. It was the session for the legislators where they bring forward their bill ideas, and there were about 7 that made the final round. And as we listened to each of the presentations, Satara's didn't make the final cut, but I was impressed because she was dealing with the idea of corrective room restrictions for juveniles in the state of Nevada, and we as a legislative body had dealt with the adult population and solitary confinement reforms. So it kind of caught my attention. And so I took the time to talk with Satara after and told her that I'd like to maybe perhaps visit if we need to do some similar reforms in the juvenile population. And so after the holidays, we got to know each other better. And before you today is a heavily amended version of the bill. I think Satara has learned that you have ideas and then you start to work with stakeholders. And the really good news here is we have found out there are some really good things that are going on and good work that are being done by those who work in the juvenile system here in Nevada. But that doesn't mean there isn't some room that we could improve a little bit. And so I'm going to turn the time over now to Satara. And also at the table is Tom Clark, who is a personal friend. Satara's best friend is Tom Clark's daughter, who's here in the audience as well. And so we'll turn the time now over to Satara.
Good morning. My name is Satara Raganti, Reganti, and I'm the youth legislator for Senate District 15. Chair Miller and members of the committee, thank you for having me today. And I'd also like to appreciate you for giving me the opportunity to speak on behalf of AB 167. I would also like to thank Assemblymember Hansen for offering to carry this bill and guiding me through this process. Earlier this year, the Nevada Youth Legislature asked each of us to propose a bill. I remember spending hours reading through legislation and thinking about the kind of impact I wanted to make. That's when I started to reflect on juvenile justice, an area that isn't always in the spotlight, but is incredibly important. I distinctly remembered meeting a woman in Washington, D.C. a few months prior who was currently involved with the Center for Children's Law and Policy. She was also familiar with the Stop Solitary for Kids campaign, which led me to look into Nevada's policies regarding corrective room restrictions. I started researching what corrective room restrictions actually looked like in our state and across the nation. I learned that Nevada allows up to 72 consecutive hours in confinement with minimal mental health involvement. It became clear that while confinement may sometimes be necessary for safety, it shouldn't be where the support ends. It should be where it begins. That was the origin of AB 167, which initially aimed to reduce the maximum hours of consecutive room confinement from 72 to 24. But after thoughtful conversations with stakeholders, including detention officials, I realized there was a more effective way to meet the same goal. So today, I'd like to speak to the amendment and not to the original bill. I want to speak to the amendment that centers on one thing we can all agree on. The mental health of our youth is vital. I'll now be going through the amendment section by section. Section 1.5 and Section 2.5. These sections require that any juvenile placed in corrective room restriction must be seen by a licensed mental health professional within 48 hours. Also under Section 1.5 and 2.5, after the juvenile has met with the mental health professional, the provider must document their observations and recommendations in writing. This report includes an explanation as to whether the juvenile could remain in room confinement or should they be moved to a less restrictive environment. This promotes accountability and provides a roadmap for staff and guardians to understand the juvenile's needs. It ensures that mental health is part of the decision-making, not an afterthought. Finally, the written recommendation must be shared with the juvenile's guardian or caretaker if applicable. This helps families stay informed and about the juvenile's rehabilitation process. Sections 1.6, 1.7, 1.9, 2.6, 2.7, and 2.9 will remain unchanged. Sections 1.8 and 2.8 will be removed. These changes streamline the bill while maintaining the core protections. This amendment doesn't remove the tool of room confinement. It just makes sure that during those moments, kids aren't left alone in the dark. It brings in support and structure. To me, this bill is about more than just mental health. It's about recognizing that even when a juvenile is confined, they're still a juvenile. They're still someone worth supporting, someone with potential. I'm 17 years old. When I recently visited a correctional facility in northern Nevada, I had the opportunity to briefly speak with 2 juveniles currently in room confinement. They were both also 17 years old. They explained why they were in room confinement, and it reinforced my belief that this bill is necessary. I am proud to bring AB 167 forward with this amendment, and I hope you'll join me in supporting it. Thank you, and I'm happy to answer any questions from the committee now.
Thank you so much. Did you have a final remark?
No, we're ready for questions. Thank you for the opportunity.
Okay, thank you so much. Of course, our questions will be directed to the bill sponsor, but as many of us often do, we have assistants at the table with us, with our co-presenters, that because sometimes they're able to respond to questions that we aren't. But our questions will be directed to the bill presenter. So with that, our first question will be from Assemblymember Gray.
Thank you, Madam Chair. Good morning. Good bill. Excellent presentation. Question, in the amendment, it says that they have to be evaluated within 48 hours of being placed in solitary. Is that to address the underlying reasons why they're being put in solitary, or for their continuation in solitary? The reason I ask is if it's within 48 hours and they're evaluated after an hour, you're not going to get a true sense of whether or not they should be able to continue in. So that's what I'm getting at.
Tara Arganti for the record. It's mainly to address any underlying issues that juvenile may be facing when they're in room confinement. However, if the mental health professional, after their evaluation and speaking with the juvenile, feels that they might not be able to remain in room confinement, they can take that to the facility. The reason why we made it within 48 hours is we understand there might be some delay in getting a mental health professional to those kids, and so that's why we made it like that.
Next question is from Assemblymember Nadeem.
Thank you, Madam Chair. Thank you so much for the presentation. So my question is that the mental health evaluation, that is for all the juveniles that are being convicted, or it is the specific ones?
Tara Arganti for the record. It's for the juveniles that are placed in corrective room restrictions, and so the mental health professional will come see them and evaluate them and do a check-in.
Okay, thank you.
Our next question is from Assemblymember LaRue Hatch.
Thank you so much, Chair, and thank you for bringing this bill and for the passion that you bring to it and the research that I know went into this. So my question is, if a mental health professional is coming to meet with a child within 48 hours, they don't have to wait in confinement for the mental health professional, correct? They could be in confinement for 2 hours, get out, and then meet with the mental health professional the next day. Is that what you're envisioning?
Tara Arganti for the record. While it's not explicitly defined in the amendment, the goal is that while the child is in room confinement, a mental health professional will come visit them, and so, yeah.
Sure, yes.
Thank you. And so I guess I just want to clarify, because in the chart that was provided of the data, I noticed that the majority of confinements are 2 hours or less. What I just want to confirm is that a child that is confined for 2 hours or less is now not going to be stuck in there waiting for the mental health professional to come before they can get released from the room. That's what I'm trying to confirm.
Tara Arganti for the question. Thank you for the clarification. Yeah, they will not be waiting in the room. It's just if they've been in that, if they're remaining in the room within 48 hours, a mental health professional must come see them, but they don't have to wait in the room for them to come see them. It's just if they're already there.
Thank you. So with that, and if a child was in confinement for 2 hours, and then the mental health professional shows up on hour 8 or hour 12, because that sometimes it just takes that long for someone to appear, will they still receive that evaluation?
Alexis Hanson, Assembly District 32. The intent of the bill is for children who are in these corrective room restrictions for a long period of time. The good news is, as we can see by the chart, the majority of kids are not in these room restrictions really much longer than 2 hours. So depending on the availability of the mental health professional, and I think that's what we're going to hear today in some of the testimony that we'll hear from, is the availability of some of the professionals to come in might be longer, and that will be a juggle for some of the jurisdictions. But again, the intent of the bill is if a child is in there up to 48 hours, the longer end, certainly we would like to have a mental health assessment or evaluation, not in the shorter term. And I think when we have someone with the expertise at the table, something that we might ask is, what does the process look like when they're coming in? Is there a mental health evaluation when they're coming in at all? But for sure, this legislation is to apply to those who are in these corrective room restrictions for long periods of time, to have that check-in. So thank you. Hope that helps.
Thank you, and I appreciate that. And just as it was noted, and when this data was shared, it was very encouraging, because often this type of data, which shows that youth are not being held at the max, which means that it's appropriately or more appropriately being handed out. But with that, back to my original question. So you're stating if a student or a child is in restrictive confined restrictive room, I'm sorry, I'm all over the place this morning. If they are confined, they will, at the longer end, 48 hours, they will absolutely receive a mental health evaluation. With someone who was at the shorter end, because again, we know the reality is someone may not be able to appear within that 2 or 3 or 4 hour window. We're not saying they will not receive a mental health evaluation. The mental health evaluation could still occur even though they've been released. Is that correct? Or is that the intent?
So I believe that is the intent, because we understand. Oh, Satara Ganti for the record, sorry. I believe that is the intent just in case there is a delay in getting that mental health professional to the child. Suppose they've been in there for 24 hours and the mental health professional arrives right when they're released. We still want to make sure they're receiving the proper care.
Okay, thank you so much. Our next question is from Assemblymember Cole.
Thank you, Chair, and thank you for this. I think it's really interesting and important for us to look at what's happening with the juveniles. So I guess my question, it's probing all at the same area that these folks are too. I guess maybe tighten up the language and have it, be clear. I'm not sure, and I'm not an expert, but I'm not sure if, just 2 hours in placement would be, like, you would be required to have a mental health evaluation, because 2 hours, I don't know. But I don't know. But tighten up the language to make sure that it's very clear that, if there is a limit, if it's over 2 hours or over 4 hours, that yes, it has to apply. And then, so maybe it's like a shall or a may kind of situation if it's under the 2 hours. I don't know, just my thought.
Satara Ganti for the record. Yeah, thank you. We'll definitely look into making that amendment, tightening the language to make sure that it encompasses all your questions. Thank you.
Thank you. Our next question is from Assemblymember Roth.
Thank you, Chair, and thank you so much for the presentation and for bringing this bill forward. My question is in regards to the 15 hours. I'm curious how you came to that number. I know that there's, research around solitary confinement for adults, and I assume that exists for juveniles as well. 15 hours seems like a really long time for a kid to be confined, and so I'm curious what research that was based on.
Tara Ganti for the record. I apologize for clarification. Is that referring to the original bill that discusses the amount of hours they can be placed in room confinement?
Well, yes, but it also contemplates under 6, section 1, sub 6, a child who is subjected to corrective room restriction for more than 15 hours must be provided. And so I'm just curious how you got to that 15 hours.
Taraganti, the record. After conducting research based on what other states are doing and looking into their policies, 15 hours seemed to be a very common number that arrived, and so that's kind of what that was based off of. But I can also get you that research regarding why we landed on 15 hours.
Okay, not seeing any additional questions, I will go ahead and open it up for testimony. Beginning here in Carson City, anyone wishing to come forward to testify in support of Assembly Bill 167.
Good morning, Chair and Committee. My name is Sabrina Schnur, and I'm here today representing the Nevada Psychiatric Association. We are in support of AB
Please spell your name.
Oh, thank you, Chair. SABRINASCHNUR. We are in support of AB 167, which limits confinement for youth in the juvenile system. I'd like to read an excerpt from the American Academy of Child and Adolescent Psychiatry on the use of solitary confinement of juvenile offenders. The potential psychiatric consequences of prolonged solitary confinement are well recognized and include depression, anxiety, and psychosis. Due to their developmental vulnerability, juvenile offenders are at particular risk of such adverse reactions. Furthermore, the majority of suicides in juvenile correction facilities occur when the individual is isolated or in solitary confinement. Solitary confinement should be distinguished from brief interventions such as time out, which may be used as a component of behavioral treatment program in facilities serving children and adolescents, or seclusion, which is a short-term emergency procedure. Seclusion should only be used for the least amount of time possible for the immediate physical protection of an individual in situations where less restrictive interventions have proven ineffective. The state should specifically prohibit the use of seclusion as a means of coercion, discipline, convenience, or staff retaliation. A lack of resources should never be a rationale for solitary confinement. The United Nations rules for protection of juvenile deprived of their liberty establish minimum standards for the protection of juveniles in correctional facilities. The UN resolution was approved by the General Assembly in December 1990 and supported by the U.S. They specifically prohibit the use of solitary confinement for juvenile offenders. Section 67 of the rule states, all disciplinary measures constituting cruel, inhuman, or degrading treatment shall be strictly prohibited, including corporal punishment, placement in a dark cell, closed or solitary confinement, or any other punishment that may compromise the physical or mental health of the juvenile concerned. In this situation, cruel and unusual punishment would be considered an Eighth Amendment violation of our Constitution. The American Academy of Child and Adolescent Psychiatry concurs with the UN position and opposes the use of solitary confinement in correctional facilities for juveniles. In addition, any youth that is confined for more than 24 hours must be evaluated by a mental health professional, the excerpt says, such as a child and adolescent psychiatrist when one is available. Thank you.
Thank you so much. Next.
Good morning to the Chair and Committee. My name is Addison Clark, C-L-A-R-K, and as Assemblymember Hansen mentioned earlier, I am Satara Ganti's best friend, but that is not the reason why I'm here to testify in support of her Assembly Bill 167 today. I'm here because I am a teen mental health advocate in Northern Nevada. I work with multiple nonprofits in Northern Nevada and throughout the state, and I have clinical suicide prevention training for adolescents. The reason I'm here is because the first and foremost thing that we were taught in that training is that when students and teenagers feel that they are isolated and alone, this is when their mental health takes the hardest hit. One of the things that I have learned during my training is that and being a teenager myself, in order to feel supported and connected with my community and with other people in my environment, I need to be able to have access to those people. I understand that in room confinement that this is regulated and that there are different things that come into play here, but I think that it's overall to understand the importance that when teens feel alone and isolated, that this is when they struggle with their mental health the most. So yeah, that's why I am here in support of Assembly Bill 167 today, and thank you very much.
Thank you, Chair and committee members. My name is Nick Shepak, N-I-C-K-S-H-E-P-A-C-K. I am here today as a board member of Return Strong and somebody who has had the absolute pleasure of working on solitary confinement issues since the 2019 session. In our extensive research, it has become abundantly clear that There are few things that happen inside correctional institutions, whether that is adult or juvenile, that are more detrimental to the individuals being held than solitary confinement and isolation. This bill takes a very measured approach, and as the sponsors mentioned, we have some really good facilities that are doing things the right way now, but without proper laws in place, all it takes is one bad actor for an individual to be held for an amount of time or in the type of situation that has irreparable damage for the rest of their lives. We should have as strict laws as possible surrounding youth isolation, and this bill moves us one step closer. Thank you.
Good morning, Angela Knott from the Washoe County Public Defender's Office, ANGELAKNOTT. Solitary confinement can have devastating effects on juveniles due to their still developing brains and heightened vulnerability. Isolation can lead to severe mental health issues, including depression, anxiety, paranoia, and even suicidal thoughts. According to the Child Crime Prevention and Safety Center website, half of all suicides occurring in juvenile facilities occurred while the minor was in solitary confinement, and 62% of those who committed suicide had a history of being placed in isolation. Research and common sense shows that children are different from adults. Isolation can cause serious psychological, physical, and developmental harm to young people who need age-appropriate services and programming for their healthy growth and development. Normal human contact and a range of age-appropriate services and programming are essential for the development and rehabilitation of young offenders. AB 167 is smart legislation that will help limit isolation and hopefully address any underlying mental health issues that a juvenile may be suffering. Thank you.
Thank you, Chair, members of the committee. Harrison Epstein, HARRISON legal extern for the Clark County Public Defender's Office. First, we just want to thank the bill sponsor and presenters for all of their work in protecting incarcerated juveniles. Subjecting children to corrective room restriction inflicts a massive psychological toll. On that note, we'd like to echo the words of the Nevada Psychiatric Association and all of the previous speakers. Guaranteeing access to mental health treatment for children after they've been released from these corrective rooms is also a measured step in lessening those psychological impacts. Dropping the maximum time these children can be placed in solitary confinement is a step in the right direction. This is a valuable piece of legislation seeking to lessen the already high negative impacts that incarceration can have on children. No child should ever be placed in solitary confinement, but if it will continue to exist as an option, it should be measured, only used as a last resort, and the children subjected to it should be given the best possible mental health access afterwards. Being more thoughtful with how we treat our children and focusing on rehabilitation instead of punishment alone will lead to better outcomes overall. Thank you.
Chair, members of the committee, Jonathan Norman, NORMAN, Nevada Coalition of Legal Service Providers. We represent over 3,000 kids in foster care between the North and the South, and a lot of those kids also have juvenile justice charges. I just want to ditto the comments. I'll be brief. I agree with everything that's been said. Thank you so much.
Good morning, Chair, members of the committee. Tess Opferman, that's OPFERMAN, here on behalf of the National Association of Social Workers. We too will do a ditto and echo everything that has been said. We're in full support of this measure. We're very concerned about the use of solitary confinement for children. We support any legislation that will limit the amount of time children are in solitary confinement, and would like to work to ending solitary confinement as a whole when possible. Thank you.
Thank you so much. Not seeing anyone else in Carson City, and I don't see anyone in Las Vegas. Broadcasting, would you please open the lines?
If you would like to testify in support of Assembly Bill 167, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 167, please press star 9 now.
Good morning, Chair and members of the committee. My name is Denise Bolaños Heredia, Bolanos and I'm the Associate Director of Return Strong, an organization that fights for the rights and dignity of incarcerated people and their families in Nevada. We support AB 167 because children should never be subjected to solitary confinement as punishment. We made important changes to solitary confinement for adults in Nevada. Children and youth should not be the exception. Solitary confinement, regardless of what it's called, has devastating effects on people's mental and emotional development. This is a common sense, compassionate step forward. It ensures that if solitary confinement is ever used, it is as a last resort, time limited, and monitored. We urge you to support AB 167 and protect our youth from this deeply damaging practice. Thank you.
Good morning, Chair Miller and honorable members of the Assembly Judiciary Committee. My name is Sebastian Rios, Sebastianrios, and I am a high school senior currently attending Leadership Academy of Nevada. I'm testifying before you today in my personal capacity to express my support for AB 167. I hope to share key takeaways and points for the legislation that I feel would positively and strongly impact the community here in the state of Nevada. To begin, I currently serve in the Youth Legislature alongside Youth Legislator Riganti. When Youth Legislator Riganti first brought her bill to the Youth Legislature, I was happy to support her efforts because, as she has shared, it is an extremely important issue of solitary confinement that we are tackling here, and youth are struggling today, right now, as we speak, with this issue. As youth legislators, we have had the opportunity to conversate with youth and hear their stories, as well as educate ourselves on the top issues facing youth today. Solitary confinement can be counterproductive to the goal of reducing recidivism if youth are not provided with the proper care. Having positive social interaction during the time of solitude can improve results, and so ensuring fair and accountability-directed practices is important for the sake of our youngest citizens. Our goal for juvenile justice should be to reduce the amount of crime committed by the youth community, and we know that mental health plays a role in determining whether youth commit a crime or not, especially when it comes to their mindset and intent. Our purpose with our juvenile justice practices ought to be to mold our youth into good law-abiding citizens, and so an effective way to do that is to provide them with individual guidance. By providing these youth with mental health services, we'll be ensuring they are making positive progress towards improvement and change, and ensuring that the confinement is not damaging progress. Many of these youth still have the capacity to do good things in their communities. Recidivism is avoidable, and so it's just about providing them the tools they need to succeed. To conclude, our juvenile justice system has the capacity to reduce recidivism and implement positive practices. The more chances we can provide youth to improve their mentality towards change, the better. Together, we can build a more active, positive, and success-driven youth community and ensure that service and not crime is the first priority of youth exiting the justice system. With that all being said, I hope AB 167 will pass so these changes can create real impact. Thank you all for your time and consideration today.
Thank you.
If you have recently joined and would like to testify in support of Assembly Bill 167, please press star 9 now to take your place in the queue. Chair, there are no other callers wishing to testify in support at this time.
Thank you so much. Then I will open it up for testimony in opposition of Assembly Bill 167. If there's anyone in Carson City that would like to oppose?
Good morning, Chair Miller and members of the committee. Thank you for the opportunity to speak today. My name is Elizabeth Flores, Elizabeth Florez, and I am the Director of the Washoe County Department of Juvenile Services. I want to start by thanking Assemblywoman Hanson and Youth Legislator Sitara Riganti for encouraging dialogue regarding AB 167 to address my concerns, but unfortunately those concerns have not been resolved. For some historical context, in 2013, juvenile justice professionals worked collaboratively with the ACLU on Senate Bill 107, which created standardized practices for the use of corrective room restriction, now codified in NRS 62B-215. At the time, the term solitary confinement was not used by juvenile justice professionals because it didn't accurately describe what was happening in juvenile facilities. In fact, most facilities had already moved towards best practices even before the bill was passed. SB 107 brought accountability and consistency to the system. When used appropriately, corrective room restriction actually helps reduce the use of force and prevents violent situations from escalating. Kids, even those that are in their rooms for longer periods of time, are not, quote-unquote, left alone in the dark. Contact occurs throughout the day to return to general population as soon as possible. To the bill presenter's concerns about mental health, no one is more attuned to the needs of these youth than the hundreds of facility staff in Nevada who provide 24/7 supervision and care. Detention staff are required under Nevada law to complete extensive training in areas like signs of suicide, suicide prevention, trauma-informed care, juvenile rights, the proper use of room restriction, and controlling the behavior of children. Staff are responsible for the health, safety, and welfare of all youth. The proposed amendment would require a mental health professional to respond to every youth in room restriction within 48 hours. This simply isn't feasible. Many facilities don't have clinicians on staff and rely on outside contractors. Those that do have staff would need to hire additional personnel or expand already strained contract providers, creating a significant fiscal impact. In addition, mental health professionals are not trained in the safe operation of detention centers, especially those who are contracted providers. In closing, we remain committed to our community and youth-serving missions. Any policy change must consider the
ma'am,
operational facilities.
Your 2
Thank
minutes
you.
are up. Thank
Thank
you.
you.
But if you have something written, please submit your comments for this. We'll have them in their entirety on the record.
Thank you, Chair.
Thank you so much.
Good morning, Chair Miller and members of the committee. My name is Allie Bannister, Alibanister, and I serve as the Chief Juvenile Probation Officer in Carson City. I'm here today to express my concerns regarding AB 167, specifically the 48-hour mandate for youth to be seen by a mental health professional when placed in corrective room restriction. As someone who works on the front lines of the juvenile justice system, I can tell you that the implementation of this bill would create significant challenges, particularly in rural jurisdictions. In many of these areas, mental health professionals are not readily available within the required 48-hour period. The staff in these rural areas often do not have clinicians on site and must rely on contracting services, which introduces both logistical and scheduling challenges. Accessing mental health professionals within such a brief time frame is not always feasible in these smaller jurisdictions. The realities of our rural communities must be considered when establishing such mandates. In these areas, it is common for mental health professionals to have schedules that are limited or stretched thin. The idea that every youth placed in corrective room restriction must be seen by a mental health professional within 48 hours could inadvertently result in delays or, in some cases, an inability to meet this mandate. I want to emphasize the work being done in Nevada's juvenile justice system, especially in our detention centers. The staff at these facilities take the safety and well-being of our youth very seriously. When a youth is placed in corrective room restriction, they are not left isolated and or without oversight. These youth continue to be monitored regularly by trained staff, and mental health evaluations are conducted on an as-needed basis, especially if there are concerns about suicidal ideation or self-harm. Our priority is always the mental and physical health of the youth, and while the thought behind AB 167 is well-intentioned, it does not reflect the practical realities of delivering timely mental health care in every jurisdiction. In addition, the juvenile justice system does not use solitary confinement like the adult system. Lastly, I want to highlight the major physical impact this mandate would have, especially for counties that do not have on-staff mental health clinicians. For those counties...
Thank you. Your time is up. Thank you. The same thing, please submit your, yes, thank you.
Good morning, Chair Miller and members of the committee. Jeff Rogan, Jeffrogan, on behalf of Clark County. Clark County is in a little bit different position than every other county in this state. We do have a cadre of mental health professionals that consist of licensed professionals as well as postgraduates who are on their way to licensure and participating in their postgraduate experiences that are required by law in order to earn their license. And those folks actually do evaluate some of our children who are in corrective room restrictions. We have concerns about the amendment, and we've been speaking with the proponents of the bill as well as the Assemblywoman with regard to these concerns. First, as some of you have raised during your questions, we believe that not every time a child is put in corrective room restrictions should there be a mandatory requirement that they actually be seen by a mental health professional. And you heard some testimony to that today from the Nevada Psychiatric Association, that it's only those children that are in corrective room restriction for 24 hours or more that should be mandated to see that mental health professional, and that's an amendment that we propose to the proponents. Second, because we utilize postgraduate interns in our facilities, we'd like to see the expansion of the bill a bit to not only be limited to licensed professionals, but also those folks that are on their way to licensure. It would have an effect on us if we're unable to use those qualified postgraduate interns to assess the child. And last, we also have some concerns about the appropriateness of a mental health professional being the one making a recommendation as to whether a child should remain in corrective room restrictions, as the amendment seems to suggest. That's a decision that really needs to be left to the professional staff in our juvenile justice system who need to make that determination amongst other factors based upon security needs as well as the mental health condition of the children. So I want to thank the Assemblywoman for bringing this forward. We look forward to working with her as well as Ms. Reganti on these specific issues. Thank you.
Thank you so much. Is there anyone else in opposition here in Carson City? Not seeing anyone here or in Las Vegas broadcasting, will you please open the lines?
If you would like to testify in opposition to Assembly Bill 167, please press star 9 now to take your place in the queue. Follow with the last 3 digits, 603. Please press star 6 to unmute your phone. You may begin.
My name is Heather Plager, Heather, Plager, and I am the Chief Juvenile Probation Officer for Elko County. I want to express concern over the bill and amendment to require that every youth placed in corrective room confinement be seen by a licensed mental health professional within 48 hours. While the mental health of youth in detention is undoubtedly important, the practical implications of this requirement in a rural setting like ours are significant and warrant careful consideration. We face severe limitations when it comes to accessing mental health professionals. The resources in our area are scarce, especially after hours or on weekends, and the availability of a licensed professional who can respond to an emergency situation is highly limited. This creates a situation where meeting a 48-hour timeline could be incredibly challenging, if not impossible. Moreover, the additional costs associated with bringing in a mental health professional after hours, particularly in urgent situations, would place an undue financial burden on our agency. These professionals are not readily available, and after hours or weekend rates are significantly higher, putting extra strain on already limited budgets. It's important to recognize that NRS 62B-215 already includes detailed and comprehensive guidelines regarding corrective room confinement. These regulations ensure that confinement is only used after less restrictive options have been exhausted and is done with the child's safety and well-being in mind. Facilities are required to conduct safety and well-being checks every 10 minutes and documents all actions involving corrective room confinement. There are strict limitations on the duration of confinement and requirements for ongoing reviews, all of which ensure that children are being treated fairly and humanely. In conclusion, while we all want to ensure that children in our care receive appropriate mental health treatment, we must balance those needs with the realities of limited resources and the practicalities of a rural setting. Mandating mental health professional involvement, especially within a 48-hour requirement, would further strain our already limited resources without providing substantial benefits in terms of improving the care of the children in our facility. The current regulations are already robust and offer adequate safeguards. Thank you.
Thank you so much. Next caller.
Caller, you're unmuted and may begin.
Hi, my name is Brandon Bird, Brandon Bird, from Churchill County Juvenile Justice Center, and I'm the director of Truman Hall. I wanted to speak with you guys today in regards to the resources of kids that have been placed on CRR. We do not participate in solitary confinement. That has a negative connotation, and I think we need to paint a broader picture and a more accurate picture of what it is that we do. When we have a kid that is acting out and they are a safety threat to themselves or others, there's times where we need to put them in a place where they are isolated and away from other youth. Once they are placed in this location, we place them, and it's per state mandates that they are placed on 10-minute checks. We continuously check on them every 10 minutes, trying to find a way to pull them out of the room in which they were placed. The one other aspect that I would like to bring up to you is that we, in a rural county, we have to contract with LCSWs and counselors. They're not always available. They take vacations. They take time off work. We have two. But what happens when they are not available to be reached? What about so if they are not available, I know that RBH has been brought up, but they do not do assessments like that. They do acute assessments looking to help youth who are in immediate state of help. Thank you.
Thank you so much. Next caller.
Chair, there are no other callers choosing to testify in opposition at this time.
Thank you.
Chair?
Yes.
Another caller has just joined and decided they would like to testify.
Yes, please accept. Thank you.
Good morning. My name is Tammy Morris, TammyMorris. I'm the Chief Juvenile Probation Officer in Douglas County. I wanted to express my concerns with this bill. We currently do not employ a mental health provider in our juvenile detention center, and it would be challenging for us to find a mental health provider to respond in a short amount of time. As others have mentioned, we also contract. This would be especially difficult on a weekend. If we were to find someone, there would be a larger fiscal impact for us as well. NRS currently requires many protections for the youth in corrective room restriction, and our detention staff undergo extensive training to meet the needs of the youth. We always have a mental health provider available for assessments should a youth express suicidal ideation or other mental health concerns. I understand the reason for this bill, and I do believe that the needs are being met currently already through NRS and through our training that we put our staff through. And as others have mentioned, we do not use solitary confinement. They are placed in their room for essentially a time out, and at times they even request to go to their room to spend some time alone. Thank you.
Chair, there are now no other callers testifying in opposition.
Thank you so much. With that, I will open it up for neutral testimony. Beginning here in Carson City, anyone wishing to testify in neutral?
Good morning, Chair Miller and members of the Assembly Judiciary Committee. My name is Carissa Pierce, Carissa Pearce, and I am the Government Affairs Manager with Children's Advocacy Alliance. CAA is an independent voice for Nevada's children with a mission to ensure that every child in Nevada thrives. And we appreciate the thoughtful direction of this bill and commend the sponsor for taking meaningful steps to protect the well-being of youth in detention facilities. The bill's reduction of allowable time in corrective room restriction and the addition of oversight mechanisms represents significant progress. The requirement that youth held in room restriction beyond 15 hours must be provided access to medical and mental health treatment is a critical safeguard that recognizes the impact isolation can have on a young person's psychological and emotional health. AB 165 addresses an urgent need that we have in Nevada, and we believe it could be even stronger if aligned more closely with Arizona's standards, which are regarded as humane and developmentally appropriate. Arizona, for example, prohibits placing youth in isolation solely based on risk status, such as risk for victimization, and ensures that educational and recreational opportunities continue uninterrupted. Finally, Arizona emphasizes that isolation must be a last resort and only for the minimum time necessary. While AB 167 moves in this direction, this bill could benefit from even stronger language around exhaustion of all other options prior to confinement. So we very much appreciate the intent of AB 167. We'll share these resources from Arizona with the sponsor and would urge the committee to consider any additional protections to strengthen the bill and further protect Nevada's children. So thank you for the opportunity to provide testimony.
Thank you so much. Is there anyone else here in Carson wishing to testify in neutral? Not seeing any, and no one in Las Vegas. Broadcasting, will you open the lines?
Chair, the public line is open and working. There are no additional callers to testify in neutral at this time.
Thank you. Then I will go ahead and close testimony and welcome the bill presenters up for any final remarks.
Thank you, Chair, and thanks to all of those who have testified. in various ways, whether in support or in opposition, and we can hopefully be able to work with them further and see what we can do. We want to make sure that we're addressing their concerns while still protecting the intent of the bill. And if it would be okay, Chair, I'd like to turn the time over to our youth legislator. Thank you.
Satara Ganti for the record. I would also like to thank those who have testified today and shown that they really do truly care about juvenile mental health at the end of the day. I'd like to address today the ACLU was referenced. I would like to mention that the ACLU has released a toolkit that explicitly outlines the harm that solitary confinement or corrective room restrictions can have on children, including psychological damage, increased suicide rates, and stunted development. Additionally, I would like to mention that AB 167's main goal today is to strengthen the partnerships with facilities between facilities and mental health professionals. And AB 167 only requires a mental health professional to complete a check-in within 48 hours and no longer reduces the amount of consecutive hours of corrective room restrictions. Additionally, it is important to note that these juveniles are the future of Nevada. We need to protect their mental health and ensure that we are focusing on rehabilitation. I look forward to working with people like Jeff Rogan from Clark County on the amendment and to establish a definition we can both agree on. The end goal is to have someone who knows enough about juvenile mental health checking in on them and making sure that they are doing okay. Thank you.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 167. Last on our agenda today is public comment. If there's anyone here in Carson City wishing to make public comment. Not seeing anyone here or in Las Vegas, so I will go ahead and broadcast. Please open the lines.
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now. Chair, there are no callers choosing to provide public comment at this time.
Thank you so much. Well, with that, I will go ahead and close public comment. We have completed all of the work before us today on our agenda. Thank you so much, members. With that, we will go ahead and adjourn, and we will begin tomorrow morning at 8:30 a.m. We are adjourned.